Injured workers have to realize that there are two classes of people that are covered under workers' compensation. Of course, you have the injured worker. That person is known as the claimant, and they have every right to be covered under the workers' compensation program. Unfortunately, on occasion, due to very serious work-related injuries, that worker passes away. What the worker needs to realize, if that worker is married or that worker has dependent children, dependents of the injured worker are the second class of people that can recover under workers' compensation. So, if a worker passes away due to complications from the injuries that were allowed during the lifetime of the injured worker, if the passing or the death of the injured worker is linked or related to the conditions allowed in his claim, either the widow or minor children can recover benefits. That's extremely important because death benefits to a widow, for example, are paid for the rest of her life. And ironically, the widow can actually recover more money per week than the injured worker because the widow's rights arise in the year of death. And if in the year of death, and it typically is true, that the benefits payable in the year of death are higher than what the worker was getting during his lifetime or her lifetime, then the widow has a right, or widower, to recover death benefits in the year of injury at a higher benefit structure than what the worker was getting during his or her lifetime. The only thing that would stop the widow's death benefits would be if she passes or if she remarries, and even if she does remarry, she's entitled to a 2-year lump sum payment, or what we call a 2-year dowry. So injured workers have to realize that when they have a work-related claim, that they need to inform their spouse if anything happens to them, to consult with an attorney, to consult with us, and we can then do the necessary investigation to see if there is a relationship between the passing and the work-related injury, and if so, we can file for death benefits. It's also very important to note, again, there's a statute of limitations for doing that. You must file a claim for death benefits within 2 years of the date of the passing of the injured worker. So it's extremely important, if there is any question at all on behalf of the widow or the widower, of the potential link between the death of the worker and the conditions allowed on the claim, that they consult with a lawyer. The quicker, the better, because we would like to take a look at the evidence that's fresh at or near the time of the passing, and if we can establish a relationship between the death and the claim that was allowed during the injured worker's lifetime, we would certainly want to file for the death benefits and financially protect the widow or widower for the rest of their life.